Thank you, Madam Clerk. Call the next case, please.
Brian Armstrong versus State of Tennessee.
Morning, Your Honors. May it please the Court. Jessica Butler with the Appellate Division of the Public Defenders Conference on behalf of Mr. Armstrong. Judge Wiedemeyer, if I could request 4 minutes for rebuttal, please.
4 minutes.
Yes.
All right. Thank you.
This is a post-conviction appeal stemming from Mr. Armstrong's conviction on 2 counts of possession of a firearm by a convicted felon and 1 count of possession of a prohibited weapon. Just for a brief factual background, this all stemmed from law enforcement conducting surveillance on Mr. Armstrong's home. I believe there were allegations that there were drugs being sold in the home. Based on their surveillance, law enforcement obtained a search warrant. They arrived on the premises to execute that warrant and seized a weapon that was clearly visible in a vehicle on the property. Mr. Armstrong was convicted and received a 15-year sentence. On appeal, trial counsel, who also then subsequently handled the appeal, challenged sufficiency of the evidence as well as a jury instruction issue. In his post-conviction petition, Mr. Armstrong raised several issues. For purposes of argument today, I'm just going to focus on the warrant issue and the motion to suppress. Unless the court has any other questions on anything else, I'll rest on the brief with regard to the other issues. Regarding a motion to suppress and ineffective assistance, in order to be successful, the defendant has to show that the motion would have been meritorious, that trial counsel's failure was objectively unreasonable, and that but for that failure, there's a reasonable probability that the outcome would have been different. And we believe that all 3 of those can be satisfied. The primary issue here is regarding whether or not the warrant complied with Tennessee Rule of Criminal Procedure 41, excuse me. We essentially have 2 different warrants here that there seems to be some discrepancy between the 2 of them. So,
was there proof at the hearing on the post-conviction petition that a motion to suppress would have been successful?
was there proof at the petition hearing that a motion would have been successful? I think it's fair to say that there was proof submitted regarding the discrepancy. I don't know that we ever necessarily got to that step.
No one testified other than the trial counsel.
Trial counsel and Mr. Armstrong, that was it.
But Mr. Armstrong, I think all he did was he had a copy or photograph of the warrant.
Yes, so law enforcement, when they executed the warrant, left the warrant and took a photograph. That is in the record. And then we also have one of the triplicate copies of the warrant in the record as well.
Which trial counsel identified and indicated that he had reviewed.
Correct, yes. But the discrepancy really is about whether or not Mr. Armstrong received that copy of the warrant. So the photograph, which I admit it is grainy, I certainly wish that we had better proof today, but I do think that it's fairly clear from the photograph that it is a single page, and that the only thing that is visible on that photograph in very thick ink is the judge's signature and the date that the warrant was issued. There's no time that's visible on that warrant. Pair that with the warrant that's in the record, the triplicate copy, that warrant is 4 pages. So already we have sort of a discrepancy about how the warrant is 4 pages, but Mr. Armstrong only received 1 page. The time is only present on one of the 4 pages, and that's page 3. So even if there's some argument that there was a backside to this page and they just didn't take a photograph of the backside, it's kind of difficult to square how page 3 would be on the back of page 1 if it's 4 pages and that sort of thing. But then, so we have an issue where it appears that the warrant that Mr. Armstrong received is, number 1, not the full warrant, but number 2, doesn't contain an hour or basically a time that the warrant was issued, which of course, that's number 1 of the requirements of Rule 41. And of course, this court and the Tennessee Supreme Court have established an exclusionary rule for some instances of noncompliance with the warrant requirement. But I think the closest thing that we get to in this case would be the Supreme Court case, State versus Lowe, where the court said that if the triplicate copy, there's a time listed on all of them, but there's some sort of discrepancy, maybe AM was circled on one and PM was circled on another, that would be something that where the exclusionary rule would kick in.
Well, let me ask you this. This is the copy that was left with your client. Is that correct?
I don't think that the record has the exact copy that was left with Mr. Armstrong.
The photograph is...
The photograph is what was left with him, yes.
And so, and your client doesn't have this copy that was left at his address?
I do not know where the copy is. I don't know where the copy is. It's not in the record. I can't tell you where the copy that he received is.
And if I understand the testimony of trial counsel was that he went and pulled the judge's copy, reviewed it, and said that the judge's signature, the time, and the date were all on there.
Right, which squares with the Exhibit 3 in the record, which is one of those copies, yes. I believe that's the same copy that's in the record, the one that trial counsel reviewed.
Is that the one that's in your reply brief? There's a copy of one in your reply brief.
I believe the photograph of what was left with Mr. Armstrong is in our brief, because again, that's a single page, and
Right, it's a single page.
the copy that's in the record is 4 pages. So I don't think all 4 pages are in our brief, but the photograph of the one that was left with Mr. Armstrong is in the brief. And the Supreme Court has stated in State versus Bobadilla that the failure to include the time on the warrant is fatal. And the reason for that obviously being is that this encroaches on a constitutional protection. So we want to ensure that everything is above board. And so the reason, specifically the court stated in Bobadilla, that the reason that the time is necessary is to ensure that the warrant was first issued, then executed, not the other way around. And without that, without the time on the copy that Mr. Armstrong received, we don't have that assurance that the warrant was first issued and then executed and not the other way around.
Let me follow up with what Judge Easter kind of started with, as far as at the post-conviction hearing, there really wasn't a motion to suppress presented to the court.
There was not.
Okay. And I'm talking about at the post-conviction hearing. There was not.
There was not.
Okay.
There was not. There were questions, yes, there were questions elicited about whether or not trial counsel considered filing a motion to suppress and why trial counsel decided not to file a motion to suppress. The arguments there were that he had reviewed the warrant and didn't see any issues within the 4 corners of the warrant, but also that even if there had been a time issue on the warrant, trial counsel stated that that was a clerical error. And then additionally, on top of that, the plain view would sort of overtake everything. Our argument, of course, would be that Bobadilla states this is not a clerical error, and none of the exclusionary rule cases have explicitly overruled that holding. So this is fatal to the warrant if the time is not included. That's number one. But number two, if the warrant was not executed properly, then law enforcement did not have a valid basis to be at the home in the first place, and the plain view would only apply if they had had a valid reason to be there. So for those reasons, trial counsel should have filed the motion to suppress. I think the case law makes it fairly clear that the motion would have been meritorious. His sort of misapprehension of Rule 41 and the current case law, I think, makes that objectively unreasonable. And obviously, this is a suppression case. This was dealing with weapons, and without the weapon, I think it would have been very difficult for the state to make its case. So there's definitely a reasonable probability that this would have come out differently. And so for those reasons, we would argue that Mr. Armstrong received ineffective assistance of counsel and that he's entitled to a new trial. If the court doesn't have any further questions, I'll rest on the brief with regards to the other issues, and we'd ask the court to reverse.
All right, thank you. All right, General Spangler, you filling in for
Mr.
someone.
Lepone, that's correct, Your Honor. Good to be here. May it please the court, Nick Spangler for the state of Tennessee. If I could, Your Honors, I might go in a little bit different order than my opposing counsel, and I do actually want to address the adequacy of the post-conviction court's order here because I think it ties in to some of my other arguments about the merits of these ineffective assistance claims. So for two reasons, there's no reason to remand here for the post-conviction court to make more findings of fact and conclusions of law. And the first reason is that the post-conviction court's order complies with 403111B as to the communication claim. So as the court knows, 403111B requires the trial court to make findings of fact and conclusions of law as to each ground in a post-conviction petition. And I think what that recognizes is there are kind of two components to every legal claim, right? There's a legal theory, and then there's also a factual basis to the claim. And that's what we have here with this ineffective communication claim. We have the legal theory of a Sixth Amendment ineffective counsel claim, and then the factual basis of that claim is a little bit more sprawling. Petitioner alleged in his petition, as well as testified, that counsel was not deficient and performed was not deficient and was that counsel only responded to one letter, counsel never spoke with him on the phone, and that counsel did not timely inform him that there would be no motion to suppress, and that counsel was not in court to discuss a plea offer. So the post-conviction court clearly addressed both the legal aspect of that claim as well as the factual basis. The court found that counsel was not ineffective because there was no deficient performance, and the court also found that that Armstrong was not prejudiced by any actions by counsel. And so my argument on the factual basis is that the court basically made a sweeping conclusion that the petitioner failed to establish by clear and convincing evidence any factual basis of his claim. And that essentially amounts to a credibility determination that none of the allegations in the petition and none of the petitioner's testimony on any of these factual basis was credible. So there is an addressing of the factual basis here. It's just a sweeping conclusion that none of those factual bases were established. That doesn't mean that the factual basis were not addressed by the post-conviction court. So the second reason we submit that the post-conviction court order here is okay is it's well established under the Swafford decision, I believe it is, from 1985, that the real reason behind 403111B is to ensure that this court has an adequate record for review on each claim. And here we clearly had that. We have the court addressing the legal claim, we have the court addressing the factual basis, and then if you look at the remainder of the post-conviction record, we clearly have a basis that the trial court denied the claim. So this is kind of a typical case, right? We have petitioner testifying as to one version of how this representation went down, and then we have counsel's version about how that representation went down. And here counsel confirmed on the record that contrary to petitioner's allegation, he met with petitioner several times, got letters from him, wrote him, and had short phone calls with him that discussed everything that you might expect in a pretrial representation. They talked about potential witnesses, petitioner's right to testify, the state's 12-year plea offer, and the reasons for not filing a motion to suppress. So here, the findings of the post-conviction court with that record clearly established the basis of the post-conviction court's rejection of this claim, and we submit the post-conviction court's order as adequate, and there's no reason to remand for the court to go sort of line by line with each factual allegation and essentially come up with the same conclusion that it's already reached, which is petitioner failed to prove those allegations by clear and convincing evidence. And we know that's a factual finding because 403110 talks about how petitioners must prove those allegations by clear and convincing evidence. So when the court finds that the petitioner hasn't established that, we know that's a factual finding.
Were those findings made in both the oral and written order? I know, as I recall from reviewing this, the court made some pretty specific findings from the bench.
Orally. I believe the finding that the petitioner failed to establish his allegations by clear and convincing evidence was only in the written order. It was not in the oral findings. But we do have in the oral findings that that the court credited counsel's testimony. We don't have a specific finding that the court didn't credit petitioner's testimony, but we essentially said that that's what the court did by finding that he failed to establish his allegations by clear and convincing evidence.
Okay, and that was in the written order?
That was in the written order, Your Honor.
In the written order, did he specifically say, I find that the communication with the petitioner was not ineffective, that the lawyer did talk to his client. Did the trial or post-conviction judge make that?
It didn't mention communication specifically. What it found was there was, a Sixth Amendment Strickland ineffective claim, and it found no deficient performance and no prejudice in that claim, and then had the broad, sort of sweeping factual conclusion that the petitioner failed to establish those allegations by clear and
But
convincing
in the
evidence.
oral findings from the bench, he
Yes.
specifically made that finding about the communications.
I don't believe there was a specific finding even in the oral communications. We just had the sort of generic IAC claim and then the factual findings, not being found by clear and convincing evidence. As to the merits of the petitioner's claims, I'll address the effective communication claim first. Again, counsel's credited testimony established that he met with Armstrong several times, got letters from him, wrote him, and had short phone calls with him. And then again, they talked about everything you might expect in a pre-trial posture. They talked about potential witnesses, Armstrong's right to testify, the state's 12-year plea offer, and the reasons for not filing a motion to suppress. So counsel was not deficient in communicating with Armstrong. But even if counsel were deficient, petitioner barely even makes an argument for prejudice on this claim. So his theory is, and this theory really only comes up in his briefing in this case, is that he showed up to court on the date that he thought a motion to suppress was going to be filed. He said counsel was not there, and then a plea offer was made that he rejected without having the opportunity to consult with counsel about that. But that only appears as argument in the appellant's brief. He did not testify that a plea offer was made that day and that he rejected that plea. He does testify that he showed up that day, thought there was going to be a motion to suppress, there wasn't one, and that counsel wasn't there on that day. But he doesn't testify as to any plea offer being made that day that he then rejected without the opportunity to consult with counsel. So we submit there's just, again, like the trial court found, insufficient proof, clear and convincing proof that allegation was established. And so that claim is also meritless and petitioner cannot establish prejudice.
You argue in your briefing that during the oral ruling of the court specifically asked, are there any other issues that were raised, and there was no response? And that was the end of it. So
That's correct, Your Honor.
does that have any significance?
It starts to feel like a waiver argument, Your Honor, but I think, we do still have the statutory requirement that the court do address all the allegations in a post-conviction petition. I think what the court was getting at there was, was there any other proof or is there any other argument on any of these claims? So I don't think it necessarily relieves us or relieves the court of its duty to address every allegation in the petition. So I guess the short answer is no, I don't think that's a super important piece to this case. And then finally, we'll address the suppression motion claim. Trial counsel competently declined to file a meritless suppression motion. So as with the communication claim, this all goes back to the factual finding of the trial court here that petitioner simply failed to establish his factual allegations by clear and convincing evidence. So the discrepancy here is this date on the warrant that the petitioner allegedly received. And really the only proof that we have of that here from the petitioner is not the warrant that he received. As opposing counsel mentioned, he had lost this warrant or couldn't provide that warrant to counsel. So really we just have his testimony that date was missing. And then in contrast to that proof, we had the copy of the warrant that the state admitted with the actual date on it. So again, this is very reasonable for the court to come to the factual conclusion that the petitioner failed to establish the lack of that date by clear and convincing evidence.
And the petitioner didn't call any other witnesses, the officers that did the search or anything like that?
No, Your Honor. As you would during a full sort of merits suppression hearing, there was none of that proof put on at all. And I did look at the exhibit, the photograph of the warrant that was discussed. I wasn't able to decipher anything from it. It may be that I had a smaller electronic copy and there is something decipherable, but I was not able to decipher anything from that exhibit in the copy that I had. And then beyond that, I think even if we avoid this question about whether the missing date on the warrant, the alleged missing date on the warrant was a technical defect or sort of a clerical error, these officers had the right to be where they were regardless of a warrant. As this court knows, typical knock and talk procedure, the officers can go on a property, go to the front door, knock and have a consensual encounter. And there was some proof in this record in the post-conviction hearing testimony. It's not as if this vehicle where they saw the weapon was sort of pulled into a garage or like in an alcove or behind the house. It was pretty apparently just out in the front driveway as the officers were walking up to the front to serve this warrant. So they had the right to be where they were when they saw this weapon in plain view. And so for that additional reason, we submit this ineffective assistance claim as meritless. And unless the court has any questions, we respectfully ask that you affirm the judgment below. Thank you.
All right, thank you, General.
Just very briefly, I think it's pretty clear, and I think it's clear that the order does not comply with 4030-111B. That statute is very specific about what the trial court needs to include in its order. And it's clear that the post-conviction court has to make findings of fact and conclusions of law with regards to each of the grounds. And I think my friend on the other side's sort of analysis of how the order reads is correct, that there are some sort of sweeping statements, but there are not specific statements with regards to each of the grounds. There were some oral findings that were made at the petition hearing, and I think that those are very specific with regards to the warrant requirement. There are no findings made orally with regards to the communication element, and that's not cured by the written order in any way. And I know that that seems very technical, but that is the statutory requirement that the trial court has to engage in, and the trial court simply did not do that in this case. So for that reason, I think it needs to be sent back for the court to make adequate findings on that point. With regards to the warrant issue, again, I certainly wish that we had better proof in the record, that there were additional pieces of evidence in the record. That being said, I think the state's arguments are mostly about the quality of the evidence and not necessarily the validity or the substance of the evidence. I think that there were obviously opportunities to present more proof. I don't think that that means that the proof that we have in the record doesn't carry the day. And with regards to this argument that the officers sort of had a right to be there and that, you know, they're free to conduct a knock and talk, I think that sort of ignores the fact that they were not there for merely a knock and talk. This might be a different situation.
Isn't this why you should have a suppression hearing? To basically, you know, address these issues? Because that would have been the issues that would have been addressed pre-trial
Correct.
If a motion had been filed. So
I do
how do you
think
get around that?
that obviously would have been best practice. That being said, with what we have in the record, I think that there's enough to show that the suppression motion, had it been filed, had merit, that trial counsel's decision not to file that based on sort of a misapprehension of the law was unreasonable, and that because of the merits of the motion, I think that there's a reasonable probability that there would have been a different outcome. Certainly, it would have been best practice to conduct sort of a suppression hearing at the petition hearing, but again, even though we don't have more evidence, I don't think that that means that the evidence we do have doesn't carry the day. And so just briefly, this argument that they had a right to be there, that they could have conducted a knock and talk, I think that that is getting very close to sort of making a warrant requirement null and void. That if they can sort of come back and say, well, we had a right to be there anyway and we observed it in plain view, that certainly sort of negates the need for a warrant at all. And that's certainly not what the Fourth Amendment provides. That's certainly not what any of the case law states. So for those reasons, we would ask the court to reverse and remand. Thank you, Your Honors.
Thank you, Ms. Butler. Well briefed, well argued. We will take it under advisement. And
We'll take a short recess.